Law of Obligation and Contract, Article 1238 to 1243. So the Article 1238, payment made by a third person who does not intend to be reimbursed by debtor, is deemed to be a donation, which requires the debtor's consent, but the payment is in any case valid as to the creditor who has accepted it. In other words, ang bayad na ibinigay ng ikatlong tao para sa inutang ng isang tao na hindi inaasang maibabalik ang kabayaran sa kanya ay kinukonsidera ng isang donasyon na nangangailangan ng kaalaman ng nagpautang. Ito ay may bisa kung sakali tinanggap ito ng nagpautang. The payment by a third person who does not intend to be reimbursed, so the Article 1238 embodies the idea that no one should be compelled to accept the generosity of another. If the paying third person does not intend to be reimbursed, the payment is deemed a donation which requires the debtor's consent to be valid. However, if the creditor accept the payment, it shall be valid as to him and the payer, although the debtor did not give his consent to the donation. Example, Cardo owes Aliana 1,000 peso without the intention of being reimbursed. Nena paid Cardo's obligation and Cardo had previously accepted Nena's generosity. In this case, Cardo is not liable to Nena and his obligation to Aliana is extinguished, but if Cardo did not consent to the donation, Nena may recover from Cardo since there has been no donation. Although originally Cardo did not intend to be reimbursed, nevertheless, the obligation of Cardo to Aliana is extinguished because the payment is valid as to Aliana who has accepted it. Next, the Article 1239. In obligation to give, payment made by one who does not have the free disposal of the thing due in capacity to alienate it shall not be valid without prejudice to the provision of Article 1427 under the title on Natural Obligations. And it means sa obligasyong magbigay, ang kabayarang ibinigay ng isang tao na walang kakayang magpasya sa bagay na dapat ibigay at kakayang maglipat sa iba ay nagsasabing ay walang bisa. And this article deals with obligation to give. The payer must have the free disposal of the thing paid, otherwise the payment is not valid. Payer who does not have the capacity to alienate the thing, such as when he is a non-compos mentis, the payment is not valid and can be annulled unless it is made by minors under Article 1427, which states that money or fungible goods delivered by a minor can no longer be recovered if they have been consumed by a creditor in a good faith. So I have an example here. Suppose Ernesto, a 40-year-old insane, transferred the title of his land to Thomas, his creditor, for the satisfaction of his debt. Such transfer is not valid, since the insane has no legal capacity. However, further reading of that law will tell us that not all transactions of an insane person are invalid. Transactions done during the lucid interval are called valid. Next, let's proceed to the Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. To whom payment must be made: A. First, to the person in whose favor the obligation has been constituted, the creditor. B. To the successor in interest, like the heirs, or to any person authorized to receive it. So the fact D owed C, instead of paying C, D deposit the money in a bank in the name for the credit of C. All these were done without C's permission. Issue: has the debt been extinguished? The answer is no. But if after efforts had been made the creditor could not be found, particularly at the place where payment is supposed to be made, the debtor cannot be held guilty of default. Next, the Article 1241, payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. So the effect of payment made to the incapacitated creditor: if the payment made to the incapacitated creditor who cannot administer his property did not benefit him, or he has not kept the thing delivered, the debtor may be compelled by the creditor to pay anew when he regains capacity, or by the letter representative during the time of the incapacity of the creditor. Inversely, if the incapacitated creditor has kept the thing delivered, or the benefited from the payment he received, the debtor is released from his obligation by virtue of payment. During the creditor is incapacitated and to cannot administer his own property, should be given to his legal representative. If there is none, the debtor may consign the thing in the court. For example, if A owes B, then the obligation matures suddenly. B got involved in a car accident that caused him to suffer, either A can choose to pay B by paying his medical expenses or consigning his payment to the court. A's payment will be valid as long as the payment he made will be beneficial to the incapacitated creditor. Next, the Article 1242, payment made in good faith to any person in a position of the credit shall release the debtor. Ito ang pagbabayad ng may utang na ginawa ng walang daya o malisya sa tao na may hawak ng utang ay magpapalaya sa nangutang sa kanyang obligasyon. For example, Nico owes Hezekiah 100 peso. Hezekiah lost the promissory note given by Nico. Nanay found the promissory note and demanded payment from Nico. Position of credit does not refer to the real creditor or his heirs or the person authorized by him or by law under Article 1240. It refers to the person who has the appearance of the creditor but who actually is not. Unless the Article 1243, payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. So, ang pagbayad ng nangutang sa may nag-utang pagkatapos ang nangutang ay kautusan ng hukuman na ipanatili ang utang ay walang bisa. So, it is 7 instances which are the garnishment and injunction. First, the garnishment, the proceeding by which a debtor's creditors is subjected to the payment of his own debt to another. And injunction, an order of the court directing a person not to do a certain things. Next, interpleader. It is a technical name of the action in which a certain person in possession of certain property wants a claimants to litigate among themselves for the same. Rule 63, Section 1. This is an example of garnishment. Janine owes Richard 1 million. Richard, in turn, owes Leo 1 million, and Leo brings an action against Richard, who claims insolvency but admits the credit which he has over Janine. Before Janine pays Richard, Janine is summoned into the proceeding and asked to retain the debt in the meantime. Thus, the debt is garnished. The reason is Janine should not pay Richard, and instead she should pay Leo. Should Leo really be a judge, the creditor of Richard in the meantime is considered invalid under the law. This is an example of interpleader. Mario has in his possession some merchandise to be delivered to the person who present the proper receipt. Ernie and Fele each has received asked Mario to turn over the property to one of them. An examination of the receipt reveals that they are of exactly the same kind. Mario does not know to whom he should deliver the property, so he files an action in court by means of which Ernie and Feli will be able to settle their conflicting rights. The court then issued an order prohibiting payment to either Ernie or Feli. In the meantime, despite the receipt of the order, Mario paid Ernie, who is the brother of the letter's sweetheart. Is said payment valid? And the answer is no. The payment here was made after the debtor has been judicially ordered to retain the debt. Evidently, Mario cannot say he paid Ernie in good faith. He had ulterior motives for his act. Otherwise, he would not have disobeyed the lawful order of the court under the law. Therefore, Mario is deemed to be a payer in bad faith. And this is an example of injunction. Ferlin owes Leia a sum of money. When Ferlin is about to pay Leia, the The relative of the letter moved to stop the payment on the ground that Leia appears to be insane. However, proceedings in court to determine Leia's sanity are still in progress. Seeking Ferlin determination to pay, the relative of Leia asked to the court for a writ of preliminary injunction restraining Ferlin from paying Leia. In the meantime, would it be advisable to Leia despite said injunction? The answer is no. It would not be advisable for Ferlin to pay while she is under injunction. Otherwise, her payment would not valid since this would be then be payment made to the creditor by the debt after the latter has been judicially ordered to retain the debt. And that's all. Thank you.